All stand, please. Court is back in session. You may be seated.
Thank you. I'm going to see we're back on the record. All counsel present. Mr. Tisdale's present. The jury is not in the courtroom. Okay. Well, Ms. Miranda, Mr. Manship, Mr. Glenn are present. Ms. Celedonio's not. Okay. Did y'all speak with Mr. Tisdale? You want to have her? You want me to wait for her?
Yes, I sent her to go get her. She had gone to the restroom now.
Okay. I'll wait. Okay, Ms. Celedonio is present. The state's present. Mr. Tisdale is present. The jury's outside the courtroom. Okay, did the defense speak with Mr. Tisdale about his right to testify or not?
Yes, sir.
Okay. Now, does he wish to testify?
No, sir.
Y'all want me to inquire, or do you not wish me to?
Yes.
Usually do. I think it's recommended. All right, Mr. Tisdale, you have that. You can keep your seat, sir. You can keep your seat. You have the absolute right, if you choose to testify at this proceeding. If you elect to testify, you would be placed under oath like the other witnesses. One or more of your lawyers could question you in the jury's presence. The state would have the opportunity to question you or cross-examine you also in the jury's presence, just like the other witnesses. The jury would be instructed to consider the testimony, your testimony, just like they would the testimony of any other witness. You also have the absolute right not to testify at these proceedings. If you elect not to, the jury has been, and they will be instructed again, they're not to consider you exercising that right not to testify as any inference or proof of guilt against you. Do you understand all that?
Yes, sir.
Now, the decision whether or not to testify at this proceeding is solely up to you. Of course, you can have, and if you wish, consult with your lawyers about that, but ultimately the decision is up to you. Do you understand that?
Yes, sir.
All right. Do you have any questions about any of those rights?
No, sir.
Now, they've advised me here, I think Mr. Manship advised me you've elected not to testify. Is that your decision you've made?
Yes, sir.
Okay, do you have any other questions about that or time to think about it?
No, sir.
Do you want to talk to your lawyers any more about it?
No, sir.
Okay, seems sufficient to me. All right. Now, this issue about the impeachment with the policy and procedures documents, in my view, there's no need to spend 2 hours on it. Here's what I suggest. Let the defense, at the appropriate time, put in the record or identify in the record on those documents which portions of them they would use to impeach which witness. The state can say they object to which portions or not object to whichever portions y'all want, and then it's in the record. In other words, it's not necessarily, in my view, to hear argument on each and every point because the defense has announced they don't seek to impeach, have a witness come in and impeach them.
Right, but
They want to proffer this into the record.
right, but they're maintaining their position that some portions of it should be admitted as extrinsic evidence. And again, I think we would be willing to agree. I've found a section I'll agree to. I'm also going to ask for a very explicit instruction from the court to the jury that these policies and procedures are being used only to whatever, the credibility of a witness. But my point is, their position is each one of these provisions should be admitted as extrinsic evidence, and so I think we need to lay a record on how that's not the case. The portions that they want.
I'm not sure I'm following it, because they're not going to question any of the witnesses and impeach them in front of the jury.
Right, but that's just that they want to offer it in as an extrinsic piece of evidence, a freestanding, impeachable piece of evidence.
Right.
And I am going to agree that some of it can be used for that.
Okay.
But some of it is clearly not. I mean, if we could come to a reasonable agreement, which is evidently we're at an impasse, that's not going to happen, then we could end this issue. But since we can't, I've got to go through every one of them to protect my record, I think. And I don't think it'll take 2 hours. It's, there's 20 issues, 30 issues we got to talk about.
Okay, well, all right. Okay, well, we can do that on our, when I say our time.
Right.
All right, and I understand the defense doesn't have any other live witnesses, if that's the right word, that you all wish to call.
Correct.
Okay. And the state's not going to present any rebuttal testimony?
No.
All right, what I'll do then is have the jury come in, let the defense publish states, I think it was 21 to the jury. I'll have y'all announce you rest if that's what y'all wish to do. I'll ask the state if y'all have any rebuttal testimony. If you say you don't have any, say no. And I'll tell the jury this closes the evidentiary portion of the trial. We can finish up the charge conference. When do y'all want to do a closing argument?
I guess the issue with resting is their case needs to remain open so they can offer the portions of the policy that we come to an agreement with.
Yeah, I'm going to let them do that, yeah.
Okay.
Just for the jury's purposes, the evidentiary portion ends. But
I don't have an objection to that as long as the defense doesn't have an objection to that procedure.
okay. I'm going to let y'all proffer what you want to proffer.
Well, Judge, what I'm hearing Mr. Bakkedahl say is that he was going to agree for us to put in some portions of the policies and procedures as extrinsic evidence in our case. Is that what you're also hearing, Judge?
Okay. So I'm going to ask you to read the following instructions. Ladies and gentlemen of the jury, the evidence you're about to receive regarding policies and procedures of the St. Lucie County Sheriff's Office should be considered by you only in weighing the credibility of a witness's testimony and not for any other purpose.
I understand that. What I'm not following y'all is they're not going to call in a witness.
I know, right, and I'm saying, so we've all acknowledged that the document itself is not hearsay, so it would be otherwise admissible as a freestanding exhibit. I'm agreeing that portions of it can be admitted. Now, the mechanism by which we do that, whether we retype it on a piece of paper, whether we block out the entire rest of the policy, I don't care. My preference is to have you read sections that we identify as being relevant, not relevant, but admissible for purposes of impeachment. So, for instance, you would say to the jury,
Without calling a witness in.
without calling a witness, it would be like a stipulation that you read in the evidence the other day. I would suggest we do it in that fashion.
Okay. All right. When do y'all wish me to read it? Before the defense rests? Before y'all announce there's no rebuttal, or when?
Yeah, it would have to be in their case. They're using it for impeachment as extrinsic evidence. It would be, if Detective Wen said the car was blue and they had a picture of the car and it was red, they would off the picture. That's, assuming it wasn't extrinsic and not admissible. But
Okay. All right.
so yeah, before they arrested, we would have to do that. And it's going to take 2 minutes.
Okay. Well, then the part y'all agree on, do that.
Yeah, I agree, Judge. But here's what they've done. They have now muddied my record. And so if they're not given an opportunity to make their argument on the points that are clearly not relevant and clearly not impeachment, despite the fact it's an utterly irrational, unreasonable argument, my record is muddied. And so we're going to have to go through each one of them. That's why I suggest we send a jury to lunch. We can resolve this before lunch and then come back and do everything you talked about and read the ones that we came to an agreement on. And they will have preserved their record, I will have made my record, and we should be fine. Does that make any sense? I don't know if I'm...
No.
It
Because
doesn't.
I understand what you're saying.
Yeah.
What I'm at a loss is we're presenting impeachment evidence
Right.
without having a witness come in and be impeached.
I think
I don't know, it seems moot to me to go through all this if the jury isn't going to hear it.
All right, so I think the court's ruling is 100% spot on, that the point of allowing the witness to come in and explain the policy puts it into context. However, let us assume for the sake of argument that the Florida Supreme Court determines that I opened the door during the course of Detective Wentz's testimony to policy and procedure issues, which I adamantly do not think I did. And then we prohibited them from offering those procedures that might be inconsistent with his testimony. That could be a problem. I think we can avoid it.
I'm not prohibiting them from doing it.
Okay.
They can do it if they wish. They said they didn't want to. I'm not prohibiting them from doing it. They've just decided they didn't want to.
That's not what they said to you. That's the problem. What they said was they don't want to do it that way. They want to do it their way. And therefore, that's their objection and they're preserving it. That's the game. The game.
Well, does the defense wish to impeach any witness
No, Your
in front of
Honor.
the jury?
The defense would ask if the state is in agreement and the state wants to stipulate the certain portions that we've highlighted as being admissible, then we would ask and we would agree to having you read for the end of our case, just like you read the stipulation for the end of the state's case, for you to read those policies and procedures that we both agree are admissible. And we would obviously, for the record, object to the other parts not coming in, but that's a whole other issue. So what we're talking about right now is for you to read the portions of the policies and procedures that both the state and the defense agree should be admissible in our case.
Okay, well, show me what you agree to.
Right, well, and that's why I'm saying we have to go through it. And we need to go through it on the record because they have to say how they think it's impeachable. I argue it's not. And because otherwise they're not making a record. You know, if my point is all they had to do is they went overboard. They identified all of these items that clearly are not applicable. If we can come to an agreement, fine. Obviously we can't, so I think we need to go through them one at a time.
Well, that's what I'm at. The part, is there any part y'all agree on? Y'all keep saying you have this agreement.
Sure.
Show me the agreement or what it is y'all agree to.
For instance, in General Order 20.04, it says notification of pursuit, and it reads officer responsibility. When a deputy initiates an act of pursuit, she will immediately activate all emergency equipment, make radio contact, call out unit identification, call sign, exact location, so forth and so on. So that one, we would agree to that. That's fine.
Okay. All right. All right. I'll have the jury come back at 1 p.m. Y'all write down what you agree to. Everybody sign off on it. If that's what y'all wish, I'll read what y'all agree to in the presence of the jury before the defense rests. The parts you don't agree to, I'll let y'all make argument. We'll go from there, I suppose. Okay. Yvonne, if you would just tell the jury they're excused to please come back at 1 p.m. Okay. All right, if y'all will talk to each other here about what y'all agree on, write down what it is you want me to read to the jury first. Let me know when you're ready and we'll come back and go through each one item by item. Okay, so I'll step off when y'all are ready. Please let me know. We'll go off the record.
I gotta